So in terms of types of terms, this is often quite difficult. Essentially what you need to do is think, once you've spotted the term, and these are usually express terms for you, then what you're looking at is how important is that express term to the contract. So if you deliver magazines, once you've had a contract, if the magazines weren't delivered, if that's a no, then it's a condition. If they would have had the contract anyway, then it's probably a warranty. And in any case, you probably should look to use the rules on innominate terms, whereby you only know what term it is when it's been breached. So it's important to establish each of these so you know which remedies are available. Remember, rights and remedies need to be discussed. So how important is the term? That's how we spot whether it's a condition or a warranty. Now, this is probably needs less explanation. Consumer Rights Act. Now, this either comes up together or comes up separately, but usually both are on the paper. So the thing to spot is then it's not a negotiation between individuals, but instead it's going to be about traders and consumers. So one person's an individual, one person is a business, or one kind of party belongs to a business or something, or runs a business. So we need to make sure then trade and consumer, you identify those. Once you've identified them, the next thing you need to do is think, is this contract for goods? As in, are they buying something? And then which outline the rules section 9, 10 and 11. Or is it for services? If it's for a service, then you've got section 49 and 52 to apply. So how are you spotting that in the problem? Well, somebody buys something from a store or business, or a person running a business, or somebody hires a service or gets something done from a business, like we said, tattoos, gardens, and so on. We've spoken about privity in the context of being a defence, or like a defence anyway, whereby you've got somebody saying, well, I've not got a contract with you because someone else bought the product or someone else hired the service. Well, another one is going to be exclusion or limitation clauses, because, of course, what you're going to do there is one party inserts a term that tries to restrict or remove liability. So you need to look at the problem in question. Usually it's at the end of the scenario. So, like, they'll go through all the problems, and at the end it'll say, however, X is not going to be liable because they said in the receipt or something that they're not going to be liable if this is the case, or we're not going to give you a refund if it's past a certain number of days, even if the item is broken. And it's usually a little sentence at the end, so make sure you read it carefully. Try to spot these before you go ahead and look at answering the question. Now, of course, the thing you need to do is consider, is the term incorporated? So is it part of the contract? And it's usually a signed document, but if it's not a signed document, there's rules for that too. Make sure there is notice given. Consider as well, is it unclear? Now, usually it won't be. If it's clear, there is no issue, so you don't need to think about how it's interpreted. But you definitely need to think about if it's valid. So, of course, consider the exclusion clause. It's usually in your exams in the context of the Consumer Rights Act. So it's usually, we're not going to give you the money back because it's after a certain date, or we said we're not going to be liable for problems for this service. So you've got section 81, 57 and 65 of the Consumer Rights Act, which essentially say that none of those rights can be restricted. So your answer is mostly going to be that the limitation or exclusion clause is invalid. But of course, you get the marks working out, don't you? So this is how to spot it. There's usually a sentence in there that says, we're not going to be liable because. Next up, we've got misrepresentation. So this is hard to spot because what this does is it looks like a negotiation. But instead of trying to spot out whether there is a contract in terms of during the negotiation, when has that contract happened, rather, what you've got is the reason for the contract being formed is wrong. So what the clue is, something at the end says, this wasn't true, or it turned out to be worthless, or turned out to be worth less. So someone's entered into a contract based on some false information and suffered some losses. And there's usually a statement in that negotiation if it looks like a negotiation, so be careful there. But the reason is wrong. So distinguish this from breach as well, because the language will be such as like cancel the contract. We wish to cancel the contract based on the false information. And the effect is the whole contract is to be cancelled or rescinded. So misrepresentation is where there's a lie or somebody didn't check the truth of a statement. Economic duress, that's simple, we've mentioned this already, but this really relates to consideration. So if somebody has a duty to do something, that is partly consideration. Now they may say, like one of the rules of consideration is, one of the exceptions to that rule is, if they go above and beyond, they can then claim extra money. Well, what we've got with economic duress is a link for that, because they put pressure on the party, and it has to be illegitimate pressure, and the rules on that, of course, go to information on that instead, but illegitimate pressure, so they say, I'm not going to finish this unless you do this, or I'm not going to do that unless you do this, and so you're doing this adding to the existing agreement. Consider, is it the existing duty, what are the exceptions, and then in any case, there might be economic duress anyway. So it's where there's pressure for the party to vary a contract or to enter a contract. We got discharged by performance. Now, this is less problematic. Usually there's a breach, okay? So, but then sometimes if somebody's been stopped from doing something, if there's partial performance, then you may need to use the rules on discharge by performance, whereby you may get a quantum merit damages. So it's just where there's been partial performance rather than full performance. Now, discharge by breach, this may come up sort of more than one time, right? Because breach of contract is where somebody goes to do something or has obligations to do something and doesn't do it in one way. And what you're looking to spot that is one or both parties have not done what they're supposed to do. In simplest terms, that's a breach. Now, the trick with this is linking it to remedies then. So whenever there's a breach, you need to go forward and explain what remedies are available. Now, frustration, again, students tend to like this one, but it can get complex. We need to make sure we spot that the contract has become either impossible to perform, so the thing is no longer available, or it's become illegal to perform. That's happened a couple of times in probably questions. I think last time was it something along the lines of an illegal sport and it was banned, or the contract has radically changed or become commercially sterilised. So you're looking, does that contract have a point anymore? So you might have things like a hotel room for a concert, you know, or some other event. And if it has been, then of course you've got that. Now the contract is completely different than to the original contract, and so they can't perform it anymore. And what you've got to look for, though, is also issues like foreseeability or a difficulty to perform rather than impossibility to perform, and you've got to analyse those problems. Now, the scenario also will usually tell you who's paid something. So X has put a deposit down for a party, or Y has paid 2 weeks worth of the payments he should have paid out 10 weeks, and then he stopped. So what you've got there is sort of, it gives you clues by giving you this person paid this amount already, so you know they weren't going to claim it back. So that's a clue there. Oh, and in any case, they will give you some facts, some figures. And finally, we have remedies. Okay, don't forget remedies. I mean, if you forget remedies, then you're not going to hit those top bands because it asks for rights and remedies every question. And so what we got them, some are specific. So if it's Consumer Rights Act, we know there are specific remedies. Misrepresentation has specific remedies. Frustration has specific remedies. Some are linked to the term as well. So you've got conditions, warranties, rescission. But you could also look for loss of profit or loss of chance as alternatives. So are they losing the opportunity to do something? Remembering we can be compensated for that. But also consider remedies even when the issues offer an acceptance. You know, for example, there's a price usually mentioned, so you've got to say what the outcome is. So you'll be asked to analyse offer and acceptance. If there is acceptance and there is a contract and the figures discussed, you're required to then explain that that is what they'd be claiming for. So they give you clues by giving you figures for remedies. You could also, at the time, anytime money's mentioned, then obviously that's what the person's going to be claiming for. It's not mentioned by accident. We need to make sure we're plucking those figures and use them for remedies. It will also help you formulate an argument as well, in terms of whether you think there's offered acceptance. Well, there is going to be if they mention figures. So conclude that there is and say they're going to be sued for breach of contract. This is the amount that they're going to be claiming for. And that's really it. So that's how to spot things. Obviously, we're not going to go through every single possibility, but some examples there. So in terms of types of terms, this is often quite difficult. Essentially what you need to do is think, once you've spotted the term, and these are usually express terms for you, then what you're looking at is how important is that express term to the contract. So if you deliver magazines, once you've had a contract, if the magazines weren't delivered, if that's a no, then it's a condition. If they would have had the contract anyway, there's probably a warranty. And in any case, you probably should look to use the rules on innominate terms, whereby you only know what term it is when it's been breached. So it's important to establish each of these so you know which remedies are available. Remember, rights and remedies need to be discussed. So how important is the term? That's how we spot whether it's a condition or a warranty. Now, this is probably needs less explanation. Consumer Rights Act. Now, this either comes up together or comes up separately, but usually both are on the paper. So the thing to spot is then it's not a negotiation between individuals, but instead it's going to be about traders and consumers. So one person's an individual, one person is a business, or one kind of party belongs to a business or something, or runs a business. So we need to make sure then trade and consumer, you identify those. Once you've identified them, the next thing you need to do is think, is this contract for goods? As in, are they buying something? And then we outline the rules, section 9, 10 and 11. Or is it for services? If it's for a service, then you've got section 49 and 52 to apply. So how are you spotting that in the problem? Well, somebody buys something from a store or business, or a person running a business, or somebody hires a service or gets something done from a business, like we said, tattoos, gardens, and so on. we've spoken about privacy